Morning, my name is Isabela Aragão. I work at VMCA Advogados, which is a law firm based in São Paulo, specialized in data protection and competition matters. Well, I have the privilege of moderating this panel today on data sharing restrictions from a Global South perspective, balancing data protection, competition, and innovation in Latin America and, of course, Global South countries more generally. I'll also have the privilege of counting with amazing experts with me today. So first we have Andrés Calderón Lopes. He is a PhD candidate at Pontifícia Universidade Católica de Chile Law School. He has an LLM at the University of Yale, a bachelor's degree from Pontifícia Universidade Católica del Peru Law School, where he is professor of competition law and constitutional law. He's a judge for the competition tribunal at INDECOPI, Peru's national competition authority. He's also a visiting researcher with the Center for Technology and Society at FGV Rio, associate researcher for the Center for Studies in Freedom of Expression and Information Access at Universidad de Palermo in Argentina, and a member of the Academic Advisor Committee for the Centro de Competencia of the University Adolfo Ibáñez in Chile. We also have with us remotely Meghna Ball. She is the director of Asia Center, a New Delhi-based technology policy-focused think tank. She's a lawyer by training with deep experience in media and emerging technology. The Asia Center is the only think tank in India that has explored the implications of ex-ante digital competition regulations empirically, and Meghna leads their work on this front. Before Asia, she worked on legal and policy strategy at the Walt Disney Company. And before Disney, she set up and led the India office for Consensus, the world's largest blockchain technology company. She regularly writes opinions for leading publications and recently co-authored The Dazzle of the Digital, a book published by Routledge that delves into digital technologies' inextricable linkage with progress and modernity in India. And finally, we have Professor Juliano Maranhão. He is professor at the University of São Paulo Law School. He's also the director of the Legal Grounds Institute and Logarithm, and the chair of the International Conference on Artificial Intelligence and Law of 2025. He is lawyer and partner of Maranhão and Menezes Advogados. So our proposal and the idea of this panel today will be to address legal challenges of complying with international regulations while exploring the impact of data sharing in Global South countries from a competition, privacy, and also innovation, artificial intelligence perspectives. More specifically, to investigate possible impacts of data sharing restrictions in objectives of development and inclusion, and whether data sharing could somehow increase consumer welfare in diverse economic and social contexts. Our goal is also to discuss development strategies and regulatory models that best meet the needs and economic realities of the Global South, including as regards the development of innovative and emerging technologies like AI, which usually benefit from data sharing. So our panel will be divided in 4 phases. The first phase will be a first round of individual interventions, where the panelists will be provided 5 minutes or so to provide their considerations about specific questions. Then we'll have a second round of individual interventions. We will open them for questions from the audience, and then you can raise your hands and I'll bring the mic to you. And finally, they will have some additional time for providing their final considerations. So as a quick start to our panel, I will direct the first question to Andres. So how does the interplay between competition and data protection occur? And more specifically, how does data sharing relate to both competition and privacy laws?
Ok. Boa tarde, tudo bem, beleza? Okay, this is as far as my Portuguese reach. Now I switch to English. First of all, I have to make the disclaimer. I don't know if it's still used to, but since I was appointed a couple of weeks ago as a judge for the Tribunal of Competition Authority in Peru, now I have to make the typical legal disclaimer that everything that I'm going to say right now represents only my view and does not necessarily coincides with the positions of the authority. Luckily, at least for the purpose of this panel, the Peruvian Competition Authority has not dealt with cases regarding the interplay between competition law and privacy. So I'm not making. I'm sure that I won't be making any statements regarding the specific Peruvian experience in that area. Although I do plan on making some more general remarks about this relation with regard to the global South as a region, or more specifically, probably maybe the global South is too ambitious, but some of the South American countries. So when we deal with the interplay between competition law and data protection legislation, we actually are dealing with a topic that has been widely discussed in many countries, and also by multilateral organizations like the OECD and UNCTAD and others, which is the interplay between competition legislation and other sector legislation. So I would think that for most of academics, practitioners, and competition authorities, we could simplify the possible solutions into three alternatives. The prevalence of competition law, the prevalence of the sector regulation, both are application of the lex specialis principle, or the application of both corpus, which of course could be the result of a specific statement or mandate to apply both regulations in separate areas, or could be also the result of just silence by the legislator, in which case every legislation and every competent authority cannot neglect their enforcement duties, and they have to apply the laws, and they would have to decide how to do so. The application of both legislations, now getting into the field of the specific interplay between competition law and privacy laws or data protection laws, does not necessarily prevent some problems, like contradictory decisions. In some other cases, it could lead to redundant decisions, and depending of the type of enforcement that it's entrusted to those bodies, it could also lead to cases with what some would consider double jeopardy, or, for instance, from the more civil law tradition, we would call it bis in idem, right? So those two, that last scenario where both laws are applied with no prevalence of any of them, I think it's the most frequent scenario, specifically when we are dealing with competition law and data protection. Data protection laws are relatively younger than competition laws, at least in the South American context. And I would think that most of those legislations, following some of the example of their European experience, they do not specifically address either competition issues, deal with market power. It's not a specific concern of those legislations, and they do not, those legislations, they do not address specifically the issue of a possible redundant or complementary enforcement of those legislations. This is why this third scenario, I think, is the most common one. And in some other cases, such as, for instance, what is happening right now with the European specific legislation dealing with market power, such as the DMA, the law specifically takes this third route, establishing that it would be applicable without prejudice to the data protection legislation, in this case, in the European case, the GDPR. As a result, when applying competition law rules or specific market power legislation such as the TMA, the law should not, or the application of the law should not affect personal data protection. So the idea is that we could conceive an ideal scenario where competition, fairness, contestability would be fostered, and also data protection, personal data protection would be protected. However, that is the ideal scenario, but as we can see, that won't always be the case. To make one or at least two final to share two final ideas before wrapping up this first intervention. We can foresee at least that some specific issues may arise, such as data protection authorities making decisions that affect competition or reduce dynamism or innovation in some markets, or we can have competition authorities making decisions that include the application of data protection rules, which, however, may not be in line with the DPA's criteria. And even if it aligns with the DPA's criteria, do not necessarily the data protection legislation foster competition goals. So I addressed this topic in a paper that I wrote that it was published last year in the Virginia Law Journal of Virginia PLOT, Virginia Law Journal of Technology, or something like that, of law and technology, that the goals of data protection legislation, even if it fosters users or data subject autonomy, for instance, like in the Meta case, in the famous Meta case brought to by the Bundeskartellamt in Germany, even when it says that the data protection legislation protects consumer choice might not coincide with consumer welfare. It could be the case, but that does not necessarily entail the same goal. And if we take a look at some of the principles and some of the rules that are established by data protection legislation, such as the free, prior, and informed consent, those rules might not necessarily be the same threshold that competition authorities look to protect or to foster. So just to leave it in that point, I would say that one of the main issues would be to try to reconcile the different goals that both legislations might be trying to protect, even though the legislators that enacted those different corpus did not have in mind that those two goals, or those more than two goals, would actually be equivalent or be following the same direction.
Perfect. Thank you so much, Andres. And I think considering the synergies and also these challenges that you have mentioned, especially as regards like this intrinsic relationship between the matters, Magna, I wanted to ask you, what are some of the current data sharing restrictions imposed globally from both a competition and privacy perspectives? And what are the risks, negative impacts regarding data sharing restrictions? And finally, can data sharing be beneficial?
Right. Thank you very much for having me here, and hello to all the panelists and hello to the audience. So let me begin. I think Andres prefaced what I'm going to say really well. He mentioned the consent provision that is in the Digital Markets Act, Article 5.2, which is essentially somewhat of a replica of the remedies that the Bundeskartellamt prescribed in its decision against Meta. And essentially what it is it's a restriction on data usage in different forms. So processing, combining, and cross-using by gatekeepers. And in India, we have our own version of the DMA, which is currently in the draft stage. It's called the Digital Competition Bill, where we have imported that provision with a few tweaks. So in India, gatekeepers, or as we call them, systemically significant digital enterprises, are forbidden from essentially either intermixing, which means combining, or cross-using data across different businesses of the SSDE, and they're also forbidden from sharing that data with any third party without the consent of both the business user as well as the end user. So the business user, let's say on an e-commerce platform, would be a seller, and the end user would be a customer like you or me. Now there's multiple problems with this. From a doctrinal perspective, it creates a privacy right in a legal person, which doesn't stand constitutionally in India, where privacy is essentially an individual right. It also, I think, conflicts with multiple IP doctrines, but I won't get into that right now. Essentially, I'd like to focus on the second part of your question, which is what are the risks and what are the challenges. Essentially, the problem with ex-ante competition regulations like the DMA and the DCB, which is the Digital Competition Bill in India, is that they consider competition, they consider competition in a very narrow frame. And essentially, they consider the relationship between business users or sellers on a platform and the platform in the narrow frame of being competitors with one another without really considering the synergies. So coming back to the data usage restrictions, essentially what they would have the effect of doing, and recital 37 of the DMA is explicit about this, they would have the effect of reducing the efficacy of targeted advertising on these platforms. Now, everyone might celebrate and say, oh, that's great, targeted advertising, it's such an intrusion on my privacy, it's so creepy, etc., etc. I apologize, my dog also has to chime in. I apologize for that. She felt very strongly about what I was saying clearly. Where was I? So yeah, it considers this narrow dynamic of competition between business users and platforms without considering the synergies. So we conducted a study on the impact such a provision would have on micro, small, and medium enterprises in India. And essentially what we discovered is that they are overwhelmingly dependent on targeted advertising for customer acquisition, for revenue generation, for cost savings, for time saving, for even foreign customer acquisition. So there is like a deep dependency of these services on these platforms and particularly on targeted advertising. Now, when you take that away, which is something we asked them as well, what would be the impact if, let's say, the targeting on these platforms that you depend on was reduced, or the efficacy of the targeting was reduced, and a majority of them indicated that they would be negatively impacted. So a majority of businesses, a majority of people on the producer side would be negatively impacted. And we wanted to understand the consumer side as well, because of course there are two sides of a market. And I'm really heartened to hear Andres talk about the consumer welfare, because that seems to be a term that is moving further and further away from the lexicon of competition authorities, definitely in the European Union, somewhat in the US, and sort of in India as well, which is quite disappointing, because I think, and I do hope that most people would agree with me, that any competition regulation must rest on the plinth of benefiting and doing right by consumers. So again, we surveyed 2,000 consumers in India who shop online, basically e-commerce consumers, and we asked them, what or how they benefit from targeted advertising, if at all, whether they do find it helpful. Only 2% of the consumers that we surveyed indicated that they do not find it helpful. They said that it reduced their search costs. It said it helped them with product discovery. So multiple efficiencies again coming up there. So I think from that standpoint, when we consider that this law stands to negatively impact, or I mean, these provisions specifically, and we can, go wider, but since we're talking only about data sharing and data usage restrictions, that this law stands to negatively impact both the producer side as well as the consumer side, then I think we have to take pause and consider what that means or what the purpose of such a law is, and particularly when a law is looking to reduce the efficiencies on platforms in order to make markets more competitive. Really, what purpose are you serving? And is it an optimal form of optimal kind of legislation? Another thing that I'd like to bring up, since we spoke about conflicts a little bit, there are data sharing provisions as well, where essentially gatekeepers or large digital platforms have to make data available, or they are restricted again from using non-public data in competition with business users, and that's particularly in India. And that again conflicts with data protection law, right? Because they would be required to share, well, the data of business users with businesses. There's no definition of what that is, and how do you define that? Because most of that data cannot be generated without the platform. And you cannot, and of course, there's a legal conflict there as well, because you cannot have any rights over raw data. So, I mean, there are multiple legal conflicts that come up a lot from IP, and some definitely from data protection as well. But the larger point is that what are we really trying to solve for when we're instituting data protection doctrines in competition? And that question has not been answered unequivocally. Really, it seems to be that it's just an attempt to add friction. And I think some additional context is necessary here, particularly in light of the DMA. The DMA was introduced to resolve a market failure created by the GDPR in the European Union, where the GDPR was brought in. It hammered many small startups and data-reliant businesses, and essentially had the effect of entrenching the position of large technology platforms, because they were able to move to compliance-friendly jurisdictions like Ireland. And this has been documented by multiple scholars there. So really, why, at least in the context of India, why are we following the European Union down this path of regulation, market failure, then market failure created by regulation, then again trying to rectify that, and now we're already seeing multiple market failures emerging from the implementation of the DMA, even though it's only been 3 months. So I'll stop there, but yeah, I think it's questionable for the global South to be following the EU down this path. Really, when it's so early and when already there are so many adverse effects coming to bear.
Perfect. Thank you so much, Magna. This was super, super interesting, and I think it helps to enlighten our panel in general. I will ask the next question to Juliano. Professor Juliano, going more from an artificial intelligence perspective, what are the main challenges for emerging technologies as regards data sharing restrictions, as mentioned by Magna? And is data sharing within the context of AI compatible with competition and privacy requirements?
Thank you very much, Isabella, for your question. And I use many hats. Today, I'm using the hat of the Legal Grounds Institute. It's a pleasure to be part of this panel and to organize this panel with VMCA law firm with which we have so many collaborations and cooperations since not only in the field of data protection, but also in the field of competition law. And this question it is really interesting to bring AI into this context, because AI really challenges the way we see, and it's bringing very difficult questions to deal with within the tools of data protection and within the tools offered by competition law. I even would change your question in terms of perspective, as you're questioning how the restrictions on data sharing may hinder the development of AI. So this question leads to a thought that data protection is given and how it is going to hinder AI. But maybe AI is a social transformation that may lead us to think, given AI, how can we handle and reinterpret data protection? And I think there is a very recent, up-to-date discussion nowadays regarding the use of data by the developers of generative AI. Actually, the discussion was raised since Meta changed its policy and informed that it's going to use the information or personal data or personal posts or content produced by its user in its platforms to develop its Meta AI, but it's something that other developers of generative AI are doing already. But the initiative by both data protection authorities and competition authorities establishing measures to hinder or to suspend the development of the technology raises an alarm for us to think, well, what's happening? Given that we are facing a big transformation in digital technologies and with social impacts that are important and are beneficial. So first, the challenge to data protection. If we take the very famous, the landmark of data protection in the world, which is the census case by the Constitutional Court in Germany, everyone makes reference to this decision as the landmark of self-determination, and et cetera, But actually, if we take this case, the use of personal data, and there was very sensitive data that were requested by the census organism, by the state. And the problem in that case was not the use for developing public policies, because this use, the purpose of this utilization of data was anonymized. According to the court, it didn't impact individuals or personalities. The problem was with the transfer of this data to municipalities. It was one particular article of the legislation on census that transferred the data to municipalities in order to organize the division or how children were, which school children would frequent, or other municipal programs that would benefit from that information. That was forbidden because the use was personalized. Then we all know the development of the legislation on this subject. And of course, it comes to definition of strict rules defining conditions for the use or the treatment of that data. And that became an analysis of strict conditions. And we lost reference to what is the purpose in the end of the use of this data. Does it hinder individuals or personalities? Does it affect? Because if you take the decision, the preliminary injunction by the Brazilian authority, it says there is a risk of irreversible damages to individuals. And that's simply not true regarding the development of generative AI systems. Because in the development of this AI system, for its very nature, it detects statistically patterns for large amount of data where naturally the personal information is going to be lost. Is only patterns on cultural traces of communication, of wordings, etc. The personal aspect is going to be lost for the very procedure of the technology. One may say, but the authorities say, but the data which is collected, it's reversible because after the AI is built, you cannot retrieve the source, and actually you cannot retrieve in those large models any source at all. But it's exactly because you cannot retrieve personal information to extract from the model, because the general patterns are incorporated in the logic, in the knowledge. It is exactly because you cannot retrieve that personalities are not being affected. It's a natural process of anonymization. So how can we handle this? Because of course there are strict rules regarding retention or changing the purpose of utilization of data that is given in the data protection legislation. How can we interpret this in a different perspective, looking to the effects or the purpose of the utilization? Even the principle of purpose control, that is a basis of the data protection legislation, is challenged also, because it has a strict reading on every different purpose must be previously established, authorized by some data, some legal basis, and etc. But what happens when we have the development of a general AI of general purpose? How can you anticipate what is the purpose? I cannot say, for instance, even with those capabilities of those systems that are not previously predicted, like you can use ChatGPT to play chess. Should we anticipate that they are going to use this data to develop chess games? So there is something wrong that must be adjusted and reconsidered in the interpretation of data protection law in order to enable the development of this technology. And this will mean we have to reinterpret it. Maybe we should really bring data protection concerns within a broader view of data ethics. Are these systems handling data ethically? And this does not only concern privacy, it concerns many other principles and interests that are not only individualistic, but also collective. Take, for instance, I say this, think, for instance, the difficulties, for instance, in Germany, this was a very polemic discussion, that many systems of AI were intended to be used to fight the pandemics, but there was limitations given by data protection. So the discussion is, should privacy be the guiding principle in the determination of these public health programs, or should we include or consider data ethics in a broader sense that involve public interests and collective concerns? So this is regarding data protection. Regarding competition, I'll be very brief. In the opening panel, there was a provocation regarding AI systems that it could also hinder competition, both coming from Luca Belli, given concentration, and also from Andrea from Global. These are really present demands that we have to think. But when we come to competition, does the development of general AI models hinder competition? Does competition should hinder then the development of AI models? If we think, of course, all the claims are legitimate, given that the use of data produced by traditional media became, there is a crisis in this field. But because this data, this information, this content is used to train those models, is there compensation for this? How can we handle this? But it is raised as a problem of competition. And also CADE, the Brazilian Competition Authority, is challenging also this case by Meta. But is this really a competition problem? Does ChatGPT competes with the services by traditional media? I'm not really sure. Of course, they compete for the attention, for advertising, but these are different services. If you deploy antitrust methodologies, they will never be considered competing services or substitutes in the sense of an antitrust analysis. So how should we handle it? Because is there a risk for democracy? Is there a risk for the business model of traditional media? Yes, these risks are present. This may affect democracy. But how can we really translate this in terms of individual protection of author or copyrights? Can we translate this as protection of personalities of individuals? Maybe we have some public concerns here that cannot be translated into data protection or the protection of competition or the protection of authorship. So this is the challenge that I may pose. In the previous panel, Luca has said, or I think Nico has said, I'm not sure, that these tools must be combined. But maybe the combination is insufficient. Maybe we are handling something that changes our very conception of law. In the field of data ethics or the regulation of AI, the subject matter of general ethics is brought about. They may claim regarding copyrights and in the development of general AI is this is unfair because we produce the content, but the digital platforms have the profit, or the AI models have the profit. We are discussing fairness. Is this ethical or not? So it's difficult to put all that in the boxes of traditional regulation of competition, of copyright, or data protection.
Perfect. Thank you so much, Juliano. So to go for the second round of the individual interventions, we will now try to focus a little bit more on Global South needs and particularities about all of this. So the first question goes to Andres. How to make data sharing compatible with both privacy and competition laws requirements, and also from this innovation perspective too. while continuing to develop and support a robust digital economy through data sharing, especially considering global South needs and specificities.
Yes. Thank you, Isabella. I would think that when we address the global South needs and particularities, I'm going to address first the particularities. We have to take into consideration that the capabilities of the enforcement of competition law, but more specifically, or more importantly, the capabilities of enforcement of data protection rules are different in the global South or in some of South American countries that what we may find, I'm sorry, in Europe. For instance, Chile, where I'm studying, they do have a legislation, a quite old legislation on data protection that do not have the typical rights. They don't have a DPA. So enforcement over there of data protection rules and some of the measures of data sharing that are currently being discussed in the context of data protection in some jurisdictions might not work. Peru, for instance, we do have a DPA. We do have a data protection legislation, but as I mentioned in my previous intervention, we don't have data sharing obligations coming from the data protection law. In the current draft that it's being discussed for the data protection regulation to the law, there is this article regarding data portability, but do not have as many specifications as we would probably want in order to have a coherent application of both privacy or data protection goals and competition law goals as well. Then we can also mention, for instance, Colombia, which may be in a good position to address both topics and reconcile both goals, in as much as their authority, their competition authority, is also the data protection authority. Well, they do have separate bodies, but within the umbrella of the Superintendencia de Industria y Comercio. But still, I believe that they do not have yet the experience of addressing issues regarding data sharing. So that's regarding particularities. I think the institutional arrangements are probably the most important challenges that from the global South we would need to address for this application of both type of rules. Regarding the necessities, I would think that when I think of the companies or the services that are provided that are quite important for end users and also for the development of economies of medium, small enterprises, as for instance, I think Megna addressed in their empirical report that they made, and which I found very interesting, because we need also to address the effects that those rules may have on those particular economies. I would probably think that rules that make great restrictions or great limitations on data sharing might hinder economic dynamism and competitive markets in countries where we do not have, or at least we don't have the same type of concerns with large platforms and that have great market power in other countries, and in which possible impact on privacy might be something of great concern for the common individuals and or small and medium enterprises. Nevertheless, that's obviously not to make a claim that we should have lesser data protection enforcement, not. But when we deal with a case that may involve data sharing or restrictions to data sharing, I would think that some of the particular needs of our countries might include the practical implementation of said obligations. For instance, I'm just gonna mention 2 or 3 topics that I think do not have a legislative solution when we need to deal with this type of case. For instance, if we are giving or recognizing the power of decision of the data subject in order to ask for either getting access to all their data in a specific format, such as a mandate of data portability, we would need to solve the question of what's the data that it's applicable to that right of portability. Is it data provided by the individual? Is it data observed by the data controller or the data bank owner? Or is it data inferred by the company, right? This is a discussion that has been addressed in other jurisdictions. And when you see the law and the experience of data protection authorities in South American countries, or even competition law authorities, probably those questions have not been answered yet. When we are dealing with data interoperability, obviously this also implies important logistic costs for the interoperating organizations, in as much as one specific format or structure of interoperability or API scheme might not fit for every situation. And also because normally when interoperability is mandated, the main concern of the authority mandating interoperability is focus on the obligations for the given party, but they do not address the obligations for the receiving party. So in the case of the receiving party, for instance, that would be probably a concern for data protection authorities, obviously, because they do not want that an organization receives personal information that do not have in place all the security measures and do not have restrictions for the for new types of resharing or dissemination of the information. But if that obligation is mandated by the competition authority, we would need to for the competition authority to be clear regarding the obligations for both parties, the giving and the receiving party of personal data. Also, I think that one case that might arise, and I'm probably here in Brazil, you may have more experience with that, is regarding the concerns by the giving party of the validity of the consent by the data subject of the authorization, and concerns regarding data management security, which from the competition law perspective, it might seem like a hidden refusal to deal, no, or something like that, refusal to share the information. But from the data protection authority, it could be a good reason to reject the authorization or the sharing of that information. So taking into account the particularities of global South countries, the need, the size of the companies that may be required to fulfill these obligations, or the lack of great experience when dealing with these two legislations that may sometimes pose some conflicts. I think that clarity in the interpretation of the law or if possible, clarity in the scope and reach of those obligations would be especially appreciated by the administrative parties, so by the subjects that are obliged to comply with those regulations.
Perfect. Thank you so much, Andres. Now, Magna, how does the context of Global South countries could affect, or should affect the development of strategies and regulatory models on data sharing within the region, including to better accommodate the region's needs and economic realities? And which factors should be taken into consideration?
I think it's a really, there's a really simple way of looking at it. Our access to information is cross-subsidized by advertising, and it has been for a long time, not only in the digital age. All your newspapers, most of your newspapers, barring the subscription-only publications, follow that same principle where there are advertisers who pay to be in the newspaper. That brings the cost of the newspaper down to the consumer. Similarly, in the digital space, you're able to access different services for free in exchange for your data. And my problem with these narratives, I mean, I've heard people go as far as saying that they wish that all online advertising was banned, is that it's an extremely elitist narrative, and it really does come from, tends to emanate from the global north, and is unfortunately imbibed in some parts of the global south without understanding the ramifications of what that means. In essence, it means moving to a subscription model for online services. Now, when we consider, the pace of digital revolutions and how they've taken flight, not across the global south, right? In terms of access to the internet, of course, there are problems in terms of, equality of quality of service and connectivity, et cetera, those caveats aside. But fundamentally, it has also been the democratization and the accessibility of different services, because they are no to low cost for a majority of people, I mean, in my country, definitely. So when you're speaking about restricting access to data, you're automatically saying that there is, in some way, shape or form, the cost of this product is going to go up. And typically, it is not the company that bears the cost. They might bear the compliance cost to some extent. And if there is any other cost that comes into providing the service, cost is defrayed by users on either side. And we're seeing that with the DMA. And the thing is that if you want to consider development strategies for the global south, then I guess you have to consider, what is it that we want to emulate? The European Union is, I wouldn't say good, but tends to focus a lot on regulatory innovation, where they come out with these experimental frameworks, and they are pretty gung-ho about implementing them, but they're very far behind in terms of innovation. Companies are, now large companies are also doing it, but for a long time, there's, companies have started refraining from launching products in the European Union because of the state of regulation and the regulatory uncertainty within that continent or within that jurisdiction. And so from that standpoint, what is it again that we're trying to achieve? When I keep coming back to this question, I know, but because I don't see a normative basis for a digital competition law or ex ante data restrictions in the name of competition. I think that it's a very thin to no normative basis. But even from an economic standpoint, there is absolutely no justification for it. All you are doing is reducing accessibility, widening the digital divide, because not only will the cost of services go up, they also become more difficult to use, right? So choice screens are I would say, incredibly unfair on, let's say, someone who is not digitally savvy, but yet they are widely propounded as, really empowering the user. They are not empowering the user at all. They are taking time away from the user. They are making these products harder to access and harder to use, and they are also creating vulnerabilities for the user as well, right? Because at the end of the day, let's say in your choice screen, though, to some extent, I would imagine they would be verified. There are apps that have malware on them, etc., and you don't know A from B. You know that you like, let's say, you're looking at different location apps. You like Google Maps, and maybe you want to download one more as well on your choice screen, and it turns out to have malware on it. So you're creating a vulnerability there as well. You basically turned your digital dividend into a vulnerability. So from that standpoint, I mean, it makes absolutely no sense. We're already seeing that, in the European Union. I mean, this is more related to self-referencing, which is slightly away from the scope of this discussion. But the organic search traffic for hotels has gone down, and the dependency on ads on online travel aggregators has increased because of the European Union's restriction on self-preferencing, but primarily on Google. So Google can no longer put its search tool or its travel comparison tool up, and that was prompting a lot of organic search results for hotels that would directly go to their website. But now that that's gone, their dependency on online travel aggregators is increased. So there are a lot of unintended consequences. We are seeing the cost of products go up. And like I said, it is a very elitist notion to say that, do away with all kinds of data sharing. Privacy must be paramount. I agree that privacy must be paramount, but I feel like there are a lot of concepts that are muddled in the name of privacy. For instance, the data leaks in the EU serve as a testament to the fact that the GDPR is not an excellent data protection law. And really, I mean, I think the overemphasis on consent, even though many scholars agree that consent is kind of a failed model. Yes, it gives you some sense of agency over, what your data, what is being done with your data, but not really, right? When you think of the reality of it, do you or do any of us really, whenever we go to a website, do we read the entire notice, the privacy notice that is put there? Do we read the privacy policies? No, we do not. And there is empirical research that has been done on this as well, where it would take the average user to about 200 hours to read the privacy policies of every website that they visit. So it's an absurd notion, and it's unfortunately being pushed in all sorts of corners where it doesn't belong, including competition regulation. And I think, from coming back to what I was saying, from an economic standpoint, it makes absolutely no sense. So yeah, I'll close there.
Thank you, Meghna. Now, Juliano, should the development of innovative and emerging technologies like AI, which usually benefit from data sharing, have an impact in privacy and competition regulations within the context of global South countries? And I think this goes what you said before a little bit about how AI should maybe have a role, play a role in this discussion, right?
Yeah, when we are thinking about the global South, the main concern is how the particularities of countries in the global South will have their particularities respected, not only in terms of cultural aspects or economical aspects, or also normative aspects. It's a legal order can be considered in the development of these policies that are global in a global digitalized world. And one of the issues is related to AI, since, for instance, again, in our case of generative AI, the main impulse is to apply those restrictions that are strictly read from the data protection law, which was somehow transplanted from Europe, for instance, if it's the case in Brazil, legislation is quite similar. But then we have an issue that training locally those general AI systems is important to avoid some bias regarding cultural aspects of a particular country. Because if you get a system of general AI trained only with North American content, if you ask the AI to picture Mexican CEO, probably there will be a man with a mustache, things like that. So to avoid those kinds of bias and to respect local aspects of language or cultural traits, it's very important to train those general AI systems with local content. But this is completely out of the discussion if you read, for instance, the material by the Brazilian Data Protection Authority. Those more general concerns regarding the ethics of AI bias are not being balanced if you look everything only with the eyes of data protection. And this may be an effect of transplanting and importing legislation from abroad, particularly from Europe, and I'm mentioning here the so-called Brussels effect. This is happening also regarding competition. We have a draft bill that is particularly inspired by the European Digital Markets Act. But what concerns with respect to adequate use of data or data sharing, there is a restriction in DMA, but if you check the Brazilian Antitrust Authority precedents, the interventions by the European authorities within subject matters of competition applied to data protection were based on the concept of exploitative abuse. The Brazilian Antitrust Authority explicitly rejects this concept. How can you make this transplantation compatible or adequate to our legal order? So what I believe that things has to be more reflected with what are concerning what are the real problems before trying to apply those boxes that are already there in the legislation. So Andres called attention to the property of data, of personal data, the data given, the data observed, or the data inferred. I think that's the real issue regarding the training of generative AI systems. It's not about protection of personalities, because those systems completely abstract from personalities. But maybe the problem is, well, are these systems using my data or the work I produce when I produce content? Who is the owner of it? Someone is making profit out of it. And it is, if you take a look, there is this incredible work, the Great Transformation by Polanyi, where he observes the Industrial Revolution and the transformation of society in the Industrial Revolution. And he points out how work has been commoditized. And the law, the work was treated as property, but it was then commoditized. And workers couldn't handle it in contrast with the power of organizations or companies. So then a new field of law was brought about. We are maybe we are watching something like the commoditization of personal data. Something that is part of the chain of value of production and etc. And so maybe the solution is will not be based on a concern on impacts on personalities, because there is no impact at all in personalities, but it's a matter of, well, there is a commoditization, companies are having profit with that. This is a problem of property, of engagement in the production of systems that are globally used, and how can we be fair about this content? Is it a problem of a competition? Certainly not. We are not, by producing content, disputing attention with GPT or Meta AI or etc. That has nothing to do also with competition. And I think by the same reason, the problem with traditional media is not exactly on competition, but maybe we have new issues to consider. How to enhance and empower individuals regarding the content they produce, and the fact that this content is used to bring about new products, new services. How can we also handle the problem of traditional media, given that the content it produces is crucial and it is important to the development of these generative AI tools? So the questions are quite different. And importing legislation may be not the right answer to the global south. For instance, all the DMA legislation does not quite consider the impact of AI within the dynamics of competition of digital markets. If we take a first look, of course, the DMA is wholly inspired on the decisions of the European Commission on practices by the big techs. So it's based on this experience, but now new players are appearing. OpenAI was not a big tech and appeared with a very competitive product. Of course, was then invested by Microsoft and etc. There are there is a testimony of present transformation of the dynamics of competition in the market. What are the lessons we have to learn? Because we cannot adopt a legislation which is based on an enforcement experience by European antitrust authorities, which are not congenial in many aspects to the enforcement of the Brazilian antitrust authority. So we cannot import it in a moment where all these markets are being challenged by new players within the advent of generative AI. Of course, we have also concerns with concentration and competition within AI markets. I think this is the main subject that authorities, regulators should be concerned with, but considering local aspects. How is the dynamic of markets, of digital markets, of AI markets in this country? How then should this be, how should competition be enhanced? No? We have a concern of concentration within AI markets. AI markets are disrupting and provoking a movement of investments and rivalry in the digital markets. So we have to understand what are the potentials of these AI markets to be competitive, or to be or to induce concentration or market power. And I think this is an important analysis that must be thought locally also considering the global aspects, because we are handling with, we are dealing with global companies. But the point is that we have to be attentive to these particular aspects before importing solutions that may be from Europe, that may be uncongenial to local countries of the global South.
Can I make a quick reaction to some of the comments of Giuliano? Because I find it very interesting that you address the issue of ownership of data that it's used to the generative AI tools, and that ownership rules, either the ones existing or maybe new ones, could be the actual topic of solution of the upcoming controversies, for instance, between news media and those digital companies that are developing generative AI. If we take a look, for instance, at the complaint that the New York Times filed against Microsoft and OpenAI, even though there is a small language regarding competitive damages, it is not an antitrust lawsuit. And I would think that they were very cautious in not following that path, because probably there wouldn't be current evidence of a significant harm to competition that can be sustained right now. So, but they do want some compensation from OpenAI and Microsoft. And I don't know if you know, there's a Latin American case, competition case that has been brought by a Chilean newspaper, the second largest Chilean newspaper, called La Tercera, against Google. And one of the claims involves the use of Gen AI and as a possible source of market harm to that company. Basically, the same theory that could be posed in the case of the New York Times. But when reading the complaint, you wouldn't find any evidence of competitive harm. There's no economic evidence of the harm being made to La Tercera, which is not to say that they are not harmed in a way, but probably not relevant for competition law enforcement. So this is probably just me sharing some thoughts, because I want to see the reaction of the people on that topic. But I do think that even companies that are complaining of the competitive harm generated caused by generative AI may be conscious that competition law enforcement at least would not be an ideal solution to the actual harm or issue that they are dealing with, and some other type of rule, maybe ownership, proprietary rules. I'm not sure that current copyright law would also be necessarily the solution, but maybe new type of legal tools might better, they might be better suited for addressing the current difficulties that they are facing.
Say something I may say later if you prefer to.
Okay, I think we can open now for one or two questions from the audience, see if you have anything else that you would like to react to the provocations to. Yeah, okay.
I may be the provocation. Some things on a lot of the arguments I heard so far, very similar arguments within Europe, interestingly, because we have, like, you know, for example, when it comes to financing of stuff, it's different in Romania, the income levels, than in Luxembourg. So Europe is not one monolith either. So it's quite interesting that some of these narratives come in a different frame here again, but I'm wondering how much they get us to solutions. So just of a couple of examples that I noted down during the debate. So for example, with the market failure because of the GDPR that we heard in the first round, then theoretically in the US, there is no GDPR. Then they would have perfect competition with hundreds of competitors. They don't. So I wonder if the GDPR, for example, is the reason why the competition is not working in Europe. I think we have 100 other problems why the competition is not working. But I wonder sometimes if that is, let's say, too simple as an answer to really come to the problem that we have. Or we also heard on the Meta, we had exactly the same debate on localization of LLMs. So they told us we need as Meta all the European data because otherwise the LLM does not speak perfect Austrian German, which it doesn't do anyways. But the interesting part there was that some of that can be done, for example, through an opt-in system. So for me, for example, in the Meta discussion and how to train LLMs, the question was not necessarily do we want that or not, but do I have a choice if my data goes in? And if, for example, Meta asks for opt-in, and I would assume 20 or 30% of the people say, yes, I think LLMs are cool, I want to give my data to it, that would still be enough data to train for local information well enough without taking the data of everybody, without asking anybody. So I think we need to go a bit more into these details in actually overcoming these things, and they may then be different in different jurisdictions. A wonderful example in Europe is usually all the Scandinavians don't give a fuck about a lot of these things, and it's about, you know, as transparent as possible. So it's a bit more complex, I think, sometimes than we had so far. One other thing that I also wanted to mention, because we actually work on it, it's super interesting, is, for example, the question of financing things through advertisement that we heard from the colleague from India. And we had exactly this problem with Pay or Okay, for example, where Meta now changed in Europe to say, if you don't agree, give us, I think, 10 euros a month. Now, if you calculate that for 36 apps, which an average European has installed per year, that would be more than the average income in the European Union to pay for. No one can afford that either. So if you look at the economics, we have to go a bit more deeper. For example, when it comes to online advertisement, they make shitloads of money per person in the US, way less in Europe. Meta publishes this data. I think it's, don't quote me on that, but it's like $20 or $30 per month in the US per user. It's $5 or $6 in the US, in Europe. So 5 times lower already. And then they usually have Asia and then rest of the world, which includes anything from Australia to Latin America. And there, the income level from advertisement is also very low. So the question of how much do they actually make with that may actually correlate to a certain extent and may not be as different, and is definitely different in the US than, for example, in the rest of the world. And even in Europe, the UK is much higher than all the other countries. So we need to go a bit deeper there to see what is really the difference. Where do we, from, for example, an advertisement model, do we have a price difference that is specific to a jurisdiction? Even within the EU, it's, in Austria, we make, I think, €1.60 per month. In the Czech Republic, which usually is a little bit lower income, they make €5. They make more money from, you know. So if we really dig into that per jurisdiction and so on, then we can get good answers and see where differences that is material or maybe even not. So I just wanted to probably look at more of these dynamics to get to an answer that is useful for everybody.
Thank you. So I have a couple of reactions to what has been said. Giuliano, you said about the fact that a lot of the theories that are used in Europe to merge privacy and competition are about exploitation and not exclusion. Couldn't we frame things from an exclusionary perspective? In the end, you don't need to prove that actual exclusion happens. So you could argue that through data accumulation, data collection in a way that doesn't respect the GDPR, they are taking advantage of this and excluding competitors from the market. So that could be a solution. The other thing that you said about not being able to predict the uses to which data are going to be put, in the GDPR, there is an exception to the purpose limitation principle when it is done for research purposes. So you can do as many secondary uses as you want, as long as you comply with certain principles. In the context of Brazil, could the sandbox that the Data Protection Authority has created for AI be a way to maybe collect the consent for secondary uses, or find mechanisms that guarantee that those secondary uses are in line with the LGPD? So these are the 2 points for you. The point on for Andres, you mentioned this issue about training with data and whether competition can be their solution for that. I mean, I have a question about the fact that maybe the solution that is used for remuneration of journalism that is based on mandatory arbitration over, you know, what is the fee that needs to be paid, maybe could be imported into this field. And if you think about it, that one was done by a competition authority in Australia. So competition could provide the solution in that sense. I wonder what you think about it. Then finally for Magna, she mentioned, I mean, some other things have been addressed already, but one thing that she said about the use of non-public data, I think the decision in the DMA and also the Amazon commitments are about the fact that the ecosystem orchestrator like Amazon cannot get access to this non-public data, and not that it needs to share them with third parties. That would be a suggestion for something that is more like looking into industrial policy for data, where you oblige them to share them with third parties of the ecosystem. It's a choice that could be done, maybe in connection with the sandbox to facilitate that there is proper information to individuals that are concerned and they give the consent or the availability to opt out. But also many of these data are not personal. You know, I mean, at least they are business data, not about the final consumers. So I wonder if you could react also to this point. And then I think there is a last question here also. We spoke too much, all right? Are you sure?
Thank you. No, just more out of curiosity, how with these issues of competition, but also opportunity for competitiveness, how do you also see opportunities with regards to the use of open source models as well? What could be pathways forward in that direction?
I think Magna could address probably the first question by, I'm sorry, what was your name? Max? Sí.
Yeah, happy to.
You can go ahead and then we can jump after.
I'll take both questions. So just to respond to you, there's a lot of empirical evidence from the European Union that has emerged over the last few years, assessing the costs of the GDPR on innovation, on particularly small businesses. I'll give one example. There's a study by scholars in NBER, and I'm happy to share the link over here if the conference organizers want to share it onwards, that considered the costs of GDPR in the entry and exit of apps and foregone innovation. So essentially, the authors collected data on 4.1 million apps between July 2016 and October 19, along with measures of their usage based on both the volume of user ratings as well as cumulative installations. Now, the authors found that the GDPR induced the exit of about a third of available apps, and in the quarters following its implementation, the entry of new apps fell by half. So I understand that there are many problems in the European Union. Of course, you know, we have limited time in panels, so all nuances cannot be covered, and I'm sorry for not, you know, I would say, being as nuanced as I should be. But there is a lot of data supporting the fact that the GDPR did create a market failure. And it's not me saying it. It's, I mean, like I said, I mean, I'm quoting empirical evidence on this. I don't remember the second part of your question, but I think, yeah, you were talking about basically the cost of data, and I mean, essentially what I said about, you know, subscriptions being the alternative. Again, I guess I was speaking in hyperbole, but it's not only subscriptions, right? Or it's not only the restriction on the usage of data that has to be considered. There are multiple other provisions that within these ex-ante competition regulations that would necessarily make products, if not more expensive, then, as I mentioned, inaccessible in multiple ways. whether it be just in adding friction, where you have to keep opting in for something. And I'm speaking from the standpoint of many Indians who are digitally illiterate, many people who are maybe not digitally savvy. And I understand that, of course, there's a heterogeneous context in Europe, and I appreciate you, and I appreciate that, and I'm not saying that it is this kind of monolith of rich people, but again, I can only really speak to the context of my country, and over here, I don't think that, based on the studies that we've done, based on the empirical evidence we've collected, none of the practices that are prescribed are found to be not anti-competitive, but welfare reducing, either on the producer side or on the consumer side. So again, when we come back to this, I understand that everyone wants to do something about these companies because they are so big and they are, they are creating a lot of social havoc. The question is whether antitrust is the correct doctrine to be doing that. And I feel like in Europe, antitrust is used as a salvo or in place of a lot of, to solve for a lot of different issues which antitrust should not be solving for. Like there's this emerging standard of preserving democracy, which is emerging in antitrust, which I think is absolutely does not have a place there. And actually, just coming to AI, Andres mentioned that there's a case that has been filed in South America where there's an antitrust component by a publisher. Well, the French Competition Authority recently just enforced copyright laws against OpenAI. And my point here is that, moving away from your questions, I'm sorry about that. My point here is that this doctrinal confusion that is being created, where these lines are being blurred, and basically you have a competition authority enforcing rules in other domains. Where does it stop? Then what happens to the basis or the fundamental basis of competition? Again, speaking about consumer welfare, there is this push to move away from consumer welfare and towards fairness and contestability. But these terms have not even been defined, and the way they are kind of the way they have been translated by regulation in the European Union and in India. It really seems to be that let's impair the ability of these large players to operate so that we can enable others to compete, without considering that these things don't play out in a vacuum, and there are multiple consequences that are obviously not foreseen, which are now coming to bear. Coming to respond to the other question, I didn't say, sorry, that the non-public data provision was about sharing. I'm sorry if I created some confusion. We have a similar provision in our draft digital competition bill, which is somewhat an import of, somewhat an imported version of the Digital Markets Act. And essentially there is within that provision another subsection that speaks about, basically ensuring data portability for both business users and end users. So I think I might have created some confusion there. The point there is, though, however, that the point I was making over there, it's not really a data protection competition intersection point, but in the context of non-public data, yes, I understand where you're coming from in the context of business user data, but like I said, that it would only be raw data. Any kind of analytics that is drawn from that necessarily would be the property of the platform, because the platform has made the effort has made the effort, has applied its mind, etc., to create that information, to create those databases. So that would be their data. And there can be under TRIPS, under the TRIPS agreement, as well as under our copyright law, there can be no property right over raw data. So essentially, this provision conflicts with both those considerations, as well as, with the doctrine of trade secrets, though we don't have a trade secret law in our country. Again, I'm speaking very specifically to the Indian context, which says that essentially, if you're saying it's non-public data, you're trying to treat it like a trade secret, and the co-creator of that trade secret would necessarily be the platform, and the co-creator of that secret or the co-owner of that trade secret cannot be excluded from that data. So all those considerations aside, I don't know if I answered your question, but essentially I wasn't talking about that being a data sharing provision, but there is a subsection within that broader section on data usage restrictions within our draft law that talks about data sharing. So that's what I was referring to. Thank you.
I'll try to be very brief in addressing each of the questions. The comment I would like to make is the first sentence of the New York Times claim in the document against OpenAI is traditional journalism is crucial for democracy. That's the real issue of the claim. How these models are impacting democracy because they undermine the sustainability of the traditional media. So it's a problem of sustainability. And then the effort to translate it into violation of copyright or violation of competition is really difficult to sustain, because there is a transformative use. It's a different use. The services are different. Is there really competition? It's not easy to put on within these boxes. And regarding, I also do not agree that we can make general statements like Europe is not anymore with the same strength in digital markets because of the general data protection rule. I think this is too general. Things have to be better scrutinized. For instance, your counter example is a good one. Let us study. Maybe in Eastern countries there was already there was already some fragilities to develop competition. So I think everything must be scrutinized, but from the local perspective. There are also those that defend that GDPR is an opportunity for European companies to develop their language models with Latin languages or German language, etc. Because so it's the general data protection will be a trade protection law to give these opportunities. So then if we think about Brazil, should we use the same strategy if this is a strategy to create a market protection? Well, maybe not, because we have, for instance, Brazil has the opportunity to be a global provider of LLMs in Portuguese. We have in our courts and in public administration, everything is digitalized in public. We have a huge amount of that data. So maybe the strategies in Brazil are regulations that provide incentives for the government to cooperate with companies to make these data open in machine readable format, which is not quite difficult to make. So for each country, there may be a different solution in terms of inclusion of the country in this global digital economy, facing the power of those leading companies. And so also considering this local perspective, I like your approach. Instead of making a transplant, I think in the next month, the Legal Grounds is going to publish impact analysis of the transplant of the DMA to the Brazilian antitrust precedents, to CADE precedents. And it's a huge impact. I like better the alternative where we try to interpret the Brazilian legislation to face the problems that these concentration in digital markets are bringing. Instead of applying a foreign and an extraneous concept like exploitative abuse. Yes, given that there is exclusion and it is an aspect of quality or impact on consumers, the degree of privacy friendliness of these companies. Maybe we can find a different balance between the consideration of those quality aspects in the evaluation of the anti-competitive impact of there are alternatives. So regarding the interpretation of Brazilian data protection law to find an exception to the development of generative AI systems, I'm not sure if this is a solution regarding research or, but maybe my proposal is try to provide a different reading of the whole legislation, not as block condition or strict conditions that authorize to read the legal basis in a different way. Not the procedures to evaluate each procedure of the treatment of data, but take a look on the purpose of the treatment of data. Is the purpose of the treatment of data affecting personalities, individual personalities? So this is another way to interpret. Maybe better than try to find a particular clause of the law. And regarding these open models, this is an important consideration before regulation competition in digital markets. As I said, let us try to understand what are the impacts of these AI generative models within the dynamics of competition of digital markets. Before regulating, before importing regulation, let us study and check what are the perspective, what is going to happen in the dynamics of competition in this country. And then the main question is, will the AI market be competitive, given that we are already glimpsing that there is concentration, etc. But there is the alternative or the possibility of open models, and we have already available open models of generative AI that may bring counter reasons to this conclusion that there will be concentration, there will be market power. Maybe there are experiences of using these open models that are quite interesting and competitive. We have to better understand what is going to happen before legislating on that. So I think it's important to understand that, and maybe the discussion should be more sophisticated to check, well, what kind of open models are better to enhance competition. So maybe a regulation on or open data, open models for AI systems would be much more effective to foster competition than an enforcement on antitrust law that is based on the European context, for instance.
Okay, a quick comment so we can all get lunch. I think, if I'm not mistaken, that the Australian news bargaining code was approved in 2021 after the market study that the ACCC conducted regarding the news market, the news online market. And probably the response of approving a specific act to address this issue shows also of the consciousness of the limitations of the regular antitrust or competition law enforcement by the authority. So I wouldn't rule out that type of solution, which I would think probably would be better suited to address a new pressing concern. However, that also poses a new challenge, especially for global South countries, which is whether those large players would abide by a new specific legislation and wouldn't take some also measure of pressure, such as the one that they have put forward in Australia or in Canada. And obviously, for instance, if we think of Peru, Chile, Colombia, maybe we don't have that economic strength as those countries. So that is also something to take into consideration. Thank you.
Guys, thank you so much. I think this has been amazing. So in benefit of time and lunchtime, I'll just wrap this up a little bit. I just wanted to give a special thanks to all the panelists for your time and your insightful information that you have shared with us. Thank you so much. And to everyone here that have attended to this panel and that have provided so many intriguing questions too. Thank you for making this more dynamic, and to CPDP Latam for all the organization, the opportunity and space that we have for discussing this amazing and complex topic. So thank you so much. Have a great lunch and a great day, and see you there. Bye-bye.